Welcome to part 2 of Fire Department Billing for Ambulance Services. This is our lecture on how to bill and how to get started and all the issues you need to know. So this is part 2 of 7 modules, hopefully to become 8 modules with your questions. So today we're going to talk about, in this part 2, can we bill for services provided anywhere, just to start with this, and then we have a couple other important topics. So let's get going. So there's a lot of discussion about something I came out with a while ago, and for some reason no other attorneys seem to be talking about this, and this is the mutual aid billing prohibition. So the question is billing outside your primary territory or your primary ambulance service certificate territory prohibited? The answer is mostly going to be yes, and if so, then what do we do about it? So I have some suggestions for you. I think these will be very interesting suggestions that you'll find. So let's start talking about the prohibition. The law says, and we get into the middle of it, and you saw a reference to this. We went through part of this for a different reason in part 1, but the law says that you may apply fees and charges only within such services' primary response territory. Now let's stop there. What do they mean by primary response territory? Is that the territory of the fire district or the fire protection district or the village? Or is that something different? Well, you'll find it may very well be something different, because they then say the primary response territory, as assigned and evidenced by a valid ambulance service certificate. Many of you refer to this as the CON, but it's an ambulance service certificate, usually hanging on your wall, which was issued by the Commissioner of Health. Now, don't worry about the rest of the language on the dates. This was all in part 1. If you have questions on it, whether you can bill if you received your territory after 1/1 of 22, and the answer is yes, of course you can, but that's all addressed in part 1. So this authorization clearly limits billing to only that area which is in the primary response territory of the fire department's ambulance service certificate. So you need to go pull that off the wall, look at the ambulance service certificate, and you need to see what the territory is. That is your limit. Now that's going to raise a lot of questions, of course. First, what if the ambulance service certificate has a territory that's listed in the ambulance service certificate, but it's outside your fire protection area? So it begs the question, is primary territory, is that for fire protection? Is that EMS protection? Well, the law, again, refers back to the ambulance service certificate. It doesn't say the fire district or the fire protection district. It could have. It knew how to, because they use those terms in Town Law 184 and other sections, but they didn't. So it's clear here that they're talking about the primary operating territory in the ambulance service certificate. So 2 quick things. If you have a contract for primary EMS protection, which aligns perfectly with the territory outlined in your ambulance service certificate, hey, there's no issue. But what if your ambulance service certificate is bigger than your primary EMS dispatch territory? Well, here the law is unclear, but let me give you the example. So you have a ambulance service certificate that says the town of Smith, but your fire district is located only in half the town of Smith. Is that allowed? Well, we think clearly the law is anything but clear. It's unclear, but it's our opinion that you can bill anywhere in your ambulance service certificate area. Why? Because that's the plain language. We don't need to try to go out and figure out what the legislature meant, which is very tough to do. The plain language says you can bill anywhere in your ambulance service certificate. Well, what can you bill for then? Well, you can bill for your BLS and your ALS services that are provided in your primary operating territory as stated in the ambulance service certificate. Again, even if it's outside your primary fire protection area, right? So if your service certificate area is bigger than your fire district or fire protection district or village, you can go outside that area. Can you bill for ALS services? Well, yeah, if it's provided for you in your area, but when we talk about ALS intercepts, we're going to see this gets a little confusing because the law didn't do us any favors by answering a lot of these questions. Can you bill for patient lift assists? Yeah, I think so, especially if there's an ALS evaluation, it may be worth it. It may not be worth billing for treating and releasing. The $50 you make, maybe it's not worth it. On the other hand, talk to your billing company. Some billing companies like to bill for it, some don't. So, but you can bill for it. Whether you should is a different issue, but you can. What about BLS first response with no ambulance? Yep, I think you can. I don't think it's worth it, but I think you can. And for that discussion, go back to the introduction, part 1. So what is this mutual aid prohibition? Why is Brad Pinsky scaring everyone, talking about you can't bill in your mutual aid territory when other attorneys don't seem to be talking about that? Well, I think it's pretty darn clear. If your department has a contract outside the territory provided for in the ambulance service certificate, even if it is your primary response territory, because let's say you're a fire district and a town contracts with the fire district to provide primary fire protection and also says, okay, and bring your ambulance along for calls outside your fire district, which are within the fire protection district. Can you bill for those? Not if your ambulance service certificate does not go so far. You are limited to where your ambulance service certificate describes. Is that fair? No, it's not fair. You know what? No private or other not-for-profit EMS corp has this restriction. The best guess I have is this was just a restriction put in to placate the for-profit ambulance companies. And look, I represent a couple of them, not a lot of them, but I get it. But still, this is an unfair restriction, which is why, as I talked about in part 1, if you are a village or a city or even maybe a town, and you can work under the General Municipal Law 122B route of billing and not the General Municipal Law 209B route of billing, which is all these laws about fire departments, that's a better option. Go the 122B route because you will not have that restriction if that's available to you. And that is a very complicated analysis, which you need an attorney who knows all about these laws to do that analysis with you and for you. Okay, so what are your options? Well, I don't like just conceding, well, the language says this, there's no way around it. Otherwise, what do you need a lawyer for other than to interpret the law? The lawyer should help you legally get around some of these prohibitions. So there are a couple of ways to do that we do quite extensively. So option 1, listen, if you've got a substantial number of mutual aid calls, which are outside the ambulance service certificate, or even if you have, it's not mutual aid, it's your primary territory, but your ambulance service certificate is a smaller area than all of your main territory, I honestly think you should consider splitting off the ambulance service from the fire department. What do you think I mean by that? Well, I've been doing this for 26 years, splitting off the ambulance from the fire department. What we do is we incorporate a separate not-for-profit entity, and we transfer the ambulance service certificate over there. The fire department effectively still manages that not-for-profit corporation, appointing the directors, and the members are all the same. There's a lot of big advantages to that. But the biggest advantage is if you are going to a lot of mutual aid calls or a lot of calls outside your territory in your primary territory, as stated in your ambulance service certificate, you're going to lose those. So the biggest advantage would be you wouldn't lose them. So there's another option. If you provide mutual aid to another municipality or district, like a fire district, city, town, or village or county, and that municipality also holds operating authority, then they could legally contract with you under the ambulance service certificate. I think this is allowed. In fact, I'm confident this is allowed. That's my belief. Have your attorney, if you want, research this on their own. But my review leads me conclusively to the opinion that you can operate under another municipality's certificate. Then they bill for your services as their services. So why do I say this is allowed? Because you're not billing. They are billing for your services, but you're not billing. You're getting a contract fee. Now, this is a very, very complicated contract for an attorney to draft. We can do it. We've been doing it for a long time. This is kind of the General Municipal Law 122B relationship that many municipalities have with another entity. But this, if you haven't drafted these before, you shouldn't be trying it for a first time here. Now, let me just note, a fire company or an ambulance company cannot vest a fire department or any other entity with the power to provide services in their certificate area. In other words, if I'm a not-for-profit ambulance company, I can't go and contract with your fire department and say, hey, you can operate under my CON. That doesn't work. But it is allowed for a city, town, village, and county. Now, if you're saying, wait a minute, General Municipal Law 122B strictly says that a town, village, city, or county is not authorized to contract with a rescue squad. Look again, this was changed. Why it was changed, I have ideas which I talk about in part 1 of this intro series. But there is no question they can now, under the new law, this was a great change, contract with the rescue squad. Gets a little complicated from there, but they can. But again, a fire company or an ambulance service can't vest you with authority. Please don't do that. That's not legally binding or allowed. So what about ALS intercepts outside your primary territory? Well, if you read the law strictly, again, it prohibits billing outside the primary operating territory. The question really is, what is outside and what's billing? And where are ALS intercept services actually provided, right? So look, I would agree that the prohibition includes ALS intercepts which are provided outside the ambulance service certificate territory. I agree. This would not prohibit ALS intercepts where the intercept was made or the ambulance traveled through your territory to get to the hospital with the patient, right? Because you're in your territory. So if you go through your territory, I don't think there's any issue. The BLS service, however, is always going to be required to bill for ALS services. So your bill is an add-on to the BLS bill submitted by the BLS agency. You're not billing. Technically, you are not billing. They are billing and then pay you a negotiated fee, which is ranging, I'm seeing, for ALS intercepts, $250 to $350. So, the law requires that a BLS agency must have a contract with an ALS agency. If you're ALS, this doesn't govern you. Now, what if you're ALS at the critical care level, if that's allowed still, and you're not paramedic? What if you don't have 24/7 ALS? Look, the law doesn't get into that. What if there's an ALS entity really far away who you get along with, who probably will never come to your calls, and there's an ALS entity right near you who you just can't get to a contractual agreement on? Doesn't say the closest ALS agency. All it says is that a basic life support service, which establishes a schedule of fees for service, shall enter, those are important words, shall enter into a contract with a provider or providers of advanced life support services to provide such advanced life support services. The contract at a minimum has to establish the fees for ALS, right, which again usually is $250, $350, and the means by which the provider will be reimbursed when the ambulance service bills for emergency medical services. So any provider of ALS with operating authority in your area should satisfy the requirement. Doesn't have to be the closest, the best, doesn't say paramedic. It could be ILS if that still exists, right? If you have EMTIs, not that those are really around. So the law is simply silent. ALS is ALS. This is what the law says. I think it can be anyone. So if you can't get a contract with your closest immediate provider, hey, go to somebody else. The law gives the ALS provider, though, the ultimate control over the BLS provider, and I really don't like this. This is unfair. Just so you understand, here the BLS provider is prohibited from billing unless it agrees to the ALS provider's terms. And I am seeing some very reasonable, but I'm also seeing a couple very unreasonable ALS intercept agreements. Again, remember, this is unfair. Not any other, right? No other separate not-for-profit or municipal service has this requirement. Only fire departments. This clearly was intended to placate the for-profits. So if you've got a reputable for-profit or commercial ambulance service, or it could be an ALS not-for-profit, could be another ALS fire department near you, could be anybody, right? Any ALS entity, you have to have a contract with at least one of them. So in that, and let me just make so clear, this is so important. Do not agree to pay any rates until they are collected. The rates you're going to be paying are, again, between $250, $350. That's where you should be ending up out of your total fee. The BLS entity, by law, is going to have to bill for the ALS provider services and then pay some money pursuant to a contract to the ALS company, right? So Who transports if both the ALS and BLS provider arrive at the same time? That should be one of the issues in your contract. Do not simply hand over the transport to the ALS provider unless you want to, right? But in that case, you get nothing. But be careful. I'm seeing that in a lot of ALS contracts. It says, oh, if we arrive at the same time or after you have to give us the patient. Bad idea. The contract's also got to deal with the question of when the ALS provider rates are due from the BLS provider. What I am seeing extremely often, unfortunately, and have seen for 2 decades, is that the ALS provider wants to get paid 30 days after the service. That ain't going to happen. You have to make sure in your contract that you will pay them the agreed upon reasonable rate after the insurance company pays. Do not become an insurer. And frankly, I don't even think this is constitutional. I don't think it's a legal restriction or requirement. If there was a case where you could challenge it under state law, I would. If there's ever that opportunity to go to court, have this declared unconstitutional or illegal, I think you've just made the BLS agency an insurance company, and that certainly is not fair, and I don't think it's legal. The contract should talk about collection obligations and restrictions. The contract should talk about HIPAA requirements, information exchanges, due diligence for billing. What if there's a complaint? What if there's accidents and injuries? All these things. What if there's no insurance? As you're going to see soon, you can't bill a patient who doesn't have insurance. Well, the ALS provider is going to want their rates. What do we do about that? All of these have to be negotiated, and it's got to be done by somebody who's familiar with these agreements. So I want to caution you, rural BLS providers, be very careful. This is bad for you, horrible for you. Frankly, it could put you out of business. Rural BLS providers, by this new law, are required to negotiate rates for an ALS provider. If you refuse to bill as a rural BLS provider, and I'll describe what rural means, you are going to be required to pay the ALS provider out of your pocket at the usual and customary rate, which is probably going to be $250 to $350. If you run 50 calls that ALS intercepted and you're not billing, you're going to have to come up with a significant amount of money, $20,000, $30,000, $40,000. That could bankrupt you. So I don't think it's legal, but right now it's the law. You want to fight it? I'm happy to fight it with you. So what is rural? How do you know if you're rural? Well, I gave you a link at the bottom, and again, you can download this video, so you can grab the hyperlink right off that. But under federal law, an ALS provider cannot bill directly when the BLS provider is not permitted to bill, unless the BLS provider is also prohibited by law from billing. So that's why this came about, because the ALS intercept in rural areas had an exception. They can bill Medicare directly because the BLS provider was prohibited by state law from billing. Well, state law, one might argue, has kind of removed this exception, this prohibition. So the ALS providers kind of negotiated with the Senate and Assembly, the drafters of this bill, to say, well, wait a minute, so we should now be able to bill the BLS provider because they choose not to bill. Okay, fine. So they chose not to bill. And unfortunately, now the ALS provider is going to look to the BLS provider if the BLS provider doesn't bill. So how do you know if you're rural? Because this only applies to rural. You look at the Goldsmith modification, you download it from here. It's a spreadsheet, and type in your zip code, your 5-digit zip code, and you will see if you're dedicated rural under the RUCA codes. If you are, this applies to you. And if this applies to you and you decide not to bill and you're a BLS agency only, you are going to be very unhappy. You're going to end up paying a lot of ALS fees if your ALS provider tells you we want them. So let's talk a little bit about the contract between the department and the municipal entity. As you know, under 209B, the law now says the authorities having control of a fire department fixes the fees. We talked about in part 1 who's in control. Well, the town is in control of a fire department that's located in a fire protection district, not fire district. A fire district controls a fire department or company within the fire district. Villages control the fire department or the company in the village. Cities control their city department located within that area. So then the law goes on to say when fees and charges are authorized pursuant to the section, then the fees and charges that are collected are then dispersed in accordance with the written contract between whatever authority is in control of the fire department. That's why we went to this slide, and the fire company. So Doesn't matter who owns the ambulance service certificate. Nope, doesn't matter. Even if the fire district, in a fire district, owns the certificate, there still has to be a contract. And let's be fair, there's a lot of work we're going to talk about. There's a lot of work for the fire company added on to them. This is going to take a lot more time if you weren't electronically on electronic PCRs. This is going to take a lot more time to do the electronic PCRs than a paper PCR. You're going to have HIPAA forms you now have to do. There's a lot more time that goes into this. So issue 1, does it matter who owns the certificate? It doesn't. There's got to be a contract anyway. Issue 2, who owns the fees? Well, the fee is owned, right, by whoever owns the ambulance service certificate. We covered that in part 1 of this series. But who maintains the fees? That's under the contract. That's what this contract says. So once the fees are received by whatever entity owns the ambulance service contract, then the contract dictates what happens with any or all the funds. We can see a lot of pitfalls here. For example, what if the municipality in control wants to lower the tax fees or receive all the money back? Right? The municipality in control can say, listen, maybe it's a town contracting with the fire department and says, you know what, we used to pay you $200,000, but you're going to get $100,000 for billing. So now we're only going to give you $100,000. Well, wait a minute. That's not fair. We're doing a ton more work. And that's why you need someone to negotiate on your behalf. If you're the fire company and you've got to enter into this contract, you should argue you're providing increased services. You're providing more tax revenue, but you shouldn't just give every dollar of it back to the taxpayers. There are increased costs for billing. So this could be difficult for you to negotiate if the municipality says, fine, you can bill, but only if we get every dollar. Look, if they want to lower taxes by 10, 15, maybe even 20%, more power to them. I think that's right. Why should the insurance companies profit? Let's have the taxpayers finally profit. And we'll talk a lot more about this in a separate module on how to educate your public and help convince your public this is a good idea. So what else should be in this contract? Well, maybe the fire company should be receiving or keeping additional monies, right? As it's spending a lot more time and on the calls at the hospital, getting face sheets and billing information, doing HIPAA training, compliance training, having a compliance officer and a HIPAA compliance officer. Maybe the fire company should be receiving, keeping billing funds that owns the ambulance service certificate. Hey, we own it, so we want more money for it. The fire company may hold a lot more cards now than it did before ambulance billing was authorized, because now it has a way to lower taxes. But you also can offer additional services. So look, we couldn't afford a new truck. We couldn't afford a new ambulance. We couldn't afford a Lucas machine. Now we can. So we want to keep this money and apply it to things we could never afford. You always can afford more things that will benefit your patients. The law also says that the entity in control of the fire department formulates rules and regulations for the collection of the monies. So you got to have assistance drafting this. This is, a lot of issues here, right? Is there a charity care policy? What do you do about patients who can prove financial hardship and maybe they have insurance but they can't pay, or there's a high deductible and they need time to pay it? What about who is billed and not billed, like firefighters or families, commissioners, employees? What are the rules for collection? What's the complaint process? What's the appeal process? What are those rules? Who to designate as a point of contact in case of a dispute? Any rules under insurance agreements, insurance laws? So there are a ton of issues which you need to talk about. So if you have questions, once again, please send us questions. We hope you will stay tuned for modules 3 to 7, and then coming up, modules 8, which will have your questions. This is Brad Pinsky on behalf of Pinsky Law Presents. See you next time.